I am Adam Bowden. I'm an attorney with Warden Smith. We have 5 offices: Wilmington, Raleigh, Greenville, New Bern, and Asheville. I work between the Raleigh and the Wilmington office. I'm a business attorney, and I have a specialization in nonprofit law, which lends itself very well to being a member of our community association practice section for corporate governance, rules enforcement, etc. Today, we're going to have a little discussion about the Americans with Disabilities Act and the Fair Housing Act. By show of hands, how many people in this room believe that the Americans with Disabilities Act applies to homeowner association, condo associations, townhome associations? We got a couple, all right. How many folks in here believe the same for the Fair Housing Act? All right, just by way for those of you viewing on video, it's about a mixed review. About half the room, I'd say about 15 out of 30 people have raised their hand for each question. Title III of the Americans with Disabilities Act is what could potentially apply to your association. And it deals with, you see it highlighted there, places of public accommodation. And so basically what we're saying here is that if you have a building which is considered a place of public accommodation, which I'll get into momentarily, then you have to have certain accessibility standards for your building and your structure. And there's a nice government building. Title II, which is not up here, deals with government buildings and things of that nature, not privately owned buildings, but Title III is what we're dealing with. Typically, your homeowners association, your condo association, your townhome community, what have you, is not considered a place of public accommodation. The reason for that is that typically only your members, their guests, and tenants are allowed to use the amenities and the common areas and facilities. And so most associations do not have to worry about the Americans with Disabilities Act. However, there are several places where you can get tripped up. I've got a list here. The most common is your swimming pool. And there's a reason I have a picture of a swim meet. Because if you want your pool to be subject to the Americans with Disabilities Act, start having swim meets at your pool. It automatically makes it become a place of public accommodation. What does that mean? It may not be a big deal if the pool meets the ADA accessibility standards. That is to allow handicapped individuals easy ingress and egress from the pool. In 2012, the federal government revised the accessibility standards, which basically require every pool to have at least one, and in most cases, 2 different entryways. We've all seen the crane, but there's also a requirement for a ramp now. An engineer can tell you how difficult it is to retrofit a pool to put in a ramp of a sufficient grade. You almost have to go the entire length of the pool to make that happen. You have to drain it. There's a lot of things. It's not a good place to be if you don't have the money to do it. The cool thing about it, though, if there is one thing that's cool about it, is that you only have to it only impacts those areas that are actually being used by the general public. And I'll give you an example. A lot of associations have a clubhouse and a pool right next to it. And they may want to rent out their clubhouse for weddings or social functions or things like that outside the neighborhood. But if they're smart about it and they close off the pool when they rent it out, only the clubhouse is considered a place of public accommodation and needs to meet the ADA requirements. But as an engineer like Kevin, Kevin's firm would tell you, is that retrofitting buildings for doorways, staircases, elevators, things like that, retrofitting is much more expensive than building it to accessibility standards from the ground up. Fair Housing Act. These are the 7 protected classes. You've got race, color, sex, religion, national origin, familial status, and handicap. You will notice age is not a protected class, nor is sexual orientation. However, some states are moving in that direction, and it could potentially get there over time that this class is expanded. But right now, this is what the Fair Housing Act prohibits discrimination based on these 7 classes. And yes, it does apply to all condominium, all townhome, all planned communities, all homeowners associations, because in the eyes of the federal government, an association is what's considered a housing provider, because they are managing, maintaining, repairing, and replacing common elements and facilities to benefit the residents therein. So, ADA applies? No, most of the time. Only under special circumstances. Fair Housing Act applies all of the time. You cannot discriminate against any of the protected classes. And I've got several examples of where that becomes a problem, but the 2 most common are family status and handicap, where associations unknowingly will discriminate. The Fair Housing Act requires what's called a reasonable accommodation. That is, if you have rules and regulations that discriminate against a protected class, you have to grant a reasonable accommodation. That is a variance. The reason I have the sign up there that says no pets is that is the most common rule that is a violation of the Fair Housing Act. I'm going to get into that in more detail as the program progresses. There are some exceptions to granting a reasonable accommodation, that is a variance from the rules and regulations, and it basically puts the burden on the association to show that it is an undue administrative and financial burden. It's hard to do, right? It's hard to show these things because the burden of proof is on the association, but it can be done, and I'll give you some examples as we move through the program. The other component of the Fair Housing Act, besides granting a reasonable accommodation, is what's called a reasonable modification. And that's where you have an owner who is requesting either an improvement or adjustment to their individual living unit or the common area. And so the 2 most common that you see are a pool lift and a ramp. I'm getting ahead of myself. If an owner, for example, is non-ambulatory, they're in a wheelchair, they have a disability. I've already said the Americans with Disability Act doesn't apply, but the Fair Housing Act does apply. So you have to grant them equal access to be able to use the pool. So if this individual comes to you and says, I want a pool lift put in the pool, you have to grant that request. The key is that they have to pay for the installation and for the lift. But you got to be careful, because once it's installed into the common area, it becomes the financial responsibility of the association to maintain it. That is why oftentimes we recommend that as a condition to putting it in, the owner has to pay to remove it when they leave the community, whether it's on common area or whether it's on their home. Another great example, and I had the picture of it, is the ramp. Most associations, aesthetically, their architectural guidelines aren't going to allow a ramp as an entry or exit to a unit. But if that same individual who needs the pool lift says, I need a ramp to be able to go into the front of my house, you want to make sure that the condition is when you move, when you sell your home, that goes away. so that you don't have a lingering problem with that. It's okay if people need it, but you don't want to have it. Some people like to have them just for their pets. Pets are not protected as pets themselves for having equal access to housing. I mentioned to you that handicap and familial status are the two protected classes where HOAs run into the most risk. And I also mentioned that age is not a protected class. However, age works its way in through familial status or family status, where you're impacting families who have children under the age of 18 differently. The most common we see is any child under 16 must be supervised at all times by their parents when using the common area. That's a violation of federal law to have that rule in place if you're subject to the Fair Housing Act. So here's some examples of some rules that are problematic if you have them. That is having adults only swim time. If you're a community that has multiple pools, saying this is the children's pool versus the adults pool, that only your parent or a legal guardian can be your supervisor, that children must wear diapers, things of this nature. One example of an exception where there's a legitimate health and safety concern is a sauna. So you could regulate that because there's been studies that show that children below a certain age, I think it's 14, can have some detrimental impact if they go into a sauna. But in most cases, you're not going to be able to legislate this in this manner. There are ways to do it. An example is you don't want, children who aren't potty trained to use the pool without a swim diaper, right? The way to get around this is to say no incontinent persons are allowed to use the pool without a diaper, because now you're taking away the status of a child. It doesn't matter what age. Just because a child is 1 doesn't mean that someone who's 90 years old may not have the same problem. Remember, age is not protected, so there's ways to legislate around it. Some additional examples that we see a lot is where, you're restricting riding bicycles and skateboards and things like that because you don't like the neighborhood punks and things like that. Those have been found to be discriminatory based on family status. Not allowing children to play. That is a family that moves into a community to allow their children to get out, ride bikes, ride skateboards, do certain things because they are a child. It's not going to work. Number 7 there, limitation on the number of children per unit. That's a big no-no. You do not want to get into that business. Municipalities can legislate this through zoning and other things, but you are not a police force, you are not a municipality, it's not something that you want to do. Disability issues. We've touched a little bit on the access ramp, on the lift for the pool, but basically most of these, what we call reasonable modifications, are going to be as a result of someone having a disability. And it has to be a qualified disability, obviously, and we'll get into that. Huge big problem, pets, right? I said pets themselves are not protected. They're not. But the ability for someone who's disabled to have a pet is protected. If it's linked, if there's a sufficient nexus between their disability and what the pet affords them. And so these are kind of the criteria as to when you're allowed to have a pet, notwithstanding what the governing documents of the association say. There are 2 types of animals. There are service animals and support animals. The law says there's only 2 kinds of animals that can be a service animal. That is a dog or a miniature horse. And that's why there's a picture of a miniature horse. These types of situations, a service animal is an animal that is specifically trained to provide, for example, a seeing eye dog or a dog that can alert someone who has a low level of hearing when someone is at the door. They've been trained to help that person live a more normal life in terms of through the services that that animal provides. So a cat is not a service animal. A snake cannot be a service animal. It's a dog or a miniature horse. And those types of things, those types of requests should be pretty apparent. If you have a resident that has no eyesight and they come up to you and say, I know the condo documents don't allow pets. This is my seeing eye dog. You're letting them have their dog. That's the law. Support animals, and I put emotional support animals, that's kind of my term for it. Support animals can be anything. They can be any type of animal. I have had notes from physicians where a person is wearing a pouch with a sugar glider, which is basically a small type of South American flying squirrel, that apparently decreases their anxiety. And they have this type of pet, okay? These types of things, when you see a support animal, it's typically related to maybe an anxiety, stress, PSTD, for a lot of our veterans, things of that nature. But there's no special training of the animal. It just lessens the symptoms that person feels. And you have to be careful about these, because a lot of times, folks want to have an animal, and I hate to be a naysayer, but if everybody did what they're supposed to do, I wouldn't have a job. But some people may not be truthful about their need for a support animal. However, if you receive a note or a letter from a physician that connects that nexus that says, yes, this person suffers severe anxiety, and this snake lessens their anxiety, well, then the snake is going to be there. I'm using extreme examples because it happens all the time. And this is kind of one of the number one places where you can get in trouble. Parking is another one. And you have to be careful with parking, because the association only has so much ability to legislate parking spaces. For example, if the parking area for a condominium is common area, the association can designate a spot and move that closer to a person's residence so that maybe they can get into their unit a little bit easier, a little bit quicker. But let's say all the parking spaces are connected as limited common element, that if I'm in unit 1, I get parking space 1. The association doesn't have control over that. They can't shuffle parking lots because the parking space is connected as a limited common element to the unit. And so you have to be careful about that. But if you have the ability as an association to grant an accommodation to, you don't have assigned parking, but to assign parking or reserve spaces, you can do it. But guess who pays for the sign and all that? The person requesting the accommodation. And it comes out when they leave the neighborhood. It's very important that you remember the purpose is to provide the person with equal access, not better access. And I'm going to give you an example of a situation where an individual was disabled, and they lived in a condo, and they wanted to be able to have DirecTV. But the issue was that they couldn't get reception from the limited common area. Under federal law, in a condominium, you can't require an association to place a dish on common area, or in other words, in this case, the roof. So this person wanted a reasonable accommodation to allow to have a DirecTV dish put on the roof of the condominium, and got the doctor to sign a note saying that, yes, this person has a disability. But they didn't put in the letter as to whether or not having DirecTV would benefit their disability, their condition. And when asked about this, the doctor said, you know what? There's no evidence that TV is good for anybody. And so I can't say that this helps alleviate their symptoms. So they didn't have to grant that accommodation because the nexus wasn't there. between the two. And there are some things you can do with breeds of dogs and things of that nature, depending on what your, if your county or city ordinance says you can't have a pit bull, well, you can't allow someone to have a pit bull even if it's a support animal. The Fair Housing Act isn't going to step in. It's going to say, okay, well, that's unreasonable because we're asking you to break the law now in order to grant the accommodation. You don't have to do that. Very important as I close. Fair Housing Act. Go see your manager. Get in touch on a case-by-case basis. There is no one-size-fits-all. But I promise you this. If the Department of Housing and Urban Development gets a complaint that you're discriminating against someone under the Fair Housing Act, they have deeper pockets than your association. It does not cost the person who makes the complaint a dime. They don't have to hire their own lawyer, but your association is going to have to lawyer up. And as Andrew Bateman from Trisure said, you need to make sure your insurance, your director and officer's liability insurance, is going to cover discrimination claims. Because behind non-monetary claims, discrimination is probably the next highest claim, right? I was denied a fence because I'm a Native American. I was denied a fence because I have 3 kids and I don't live with the dad. This is what people say. And it happens. And sometimes, unfortunately, there is real discrimination. Most of the time, it's just the association doing its job. But these laws are here to protect people, and they can be used to really hurt an association if you're not aware of it. That concludes this portion of the presentation, and I believe I've got some time for questions.
Okay, Fair Housing Act applicability toward guests, for example. You mentioned swimming pool, you got to be careful about specific hours like for children. What about for guest children?
The question is, how does the Fair Housing Act apply to the guests of a member? And the answer is it applies identically. It applies equally to members, their guests, and the tenants. And so you can't discriminate based on those classes under the Fair Housing Act. Because, and I'll give you an example, you're then legislating maybe the children who live in the community, their ability to hang out with their friends who don't live in the community, whereas you're not doing that to anyone else, saying, you can't regulate how people can visit. You might be able to say, hey, Adam's not allowed to drive in Andrew's neighborhood because he's a crazy man, but you still have to give me access to the community.
Even if it's 55 and older, as legislature knows about?
That's a great question. 55 and older is the one exemption. If you have a 55 and older qualified community, there are exceptions for the discrimination of family status. That's an exemption. But you're waiving that right. That's correct. And that's under federal law as well.
Parking in condominiums, there are no assigned spaces. Someone calls who is thinking of buying a condo. So my first question is if they're not actually an owner. But I'm thinking of buying this condo and I want a reserved parking spot right in front of the building. Is that possible? How do you answer that? Is the fact that he's not yet an owner, does that make an impact?
The question is, you have a non-owner who's thinking about buying in the community, and they want, as a condition to buying the unit, a reserved parking space. And we'll assume for the purposes of this question that they're qualified as disabled. The answer is no. The association doesn't owe any duty except to the owner, the member, their guest, or a tenant. So the response is that if you buy the unit, you can then apply for a reasonable accommodation at that point in time. Because remember, they're going to have to pay, if they meet the criteria, they will have to pay to have that spot designated, et cetera, et cetera.
Because I thought the parking slide said they should be guaranteed equal access. But this would be over equal access, requesting the very front parking space.
It's equal access, not better, but someone who has a disability, you're making it easier for them, which is equal access, if it were, to get in and get out from the building. But for example, let's say, and then I'll wrap this up, this will be the end, but for example, we've had a situation where there's 2 elevators in a condominium building. One is a service elevator, and one is a regular, individual elevator, where someone with a disability has said, well, I want a key to the service elevator because I don't want to have to wait for the regular elevator, but the service elevator is further away from the regular elevator. You wouldn't have to grant them a key because then that's better access, right? They have equal access, that is, but if the service elevator were closer or were closer to their parking space, then you might have to consider granting an accommodation at that point. I appreciate everyone's attention.